but is acting in clear opposition to the will of the citizens. Georgia is as reflected of the election, which went red, voted for President Trump. Even harassing subpoenas could, under certain circumstances, threaten the independence or the effectiveness of the president. If a sitting president is intensely unpopular in one district, like in New York, and that is a common condition, targeting the president may be alluring and an effective electoral strategy, like in D.C., which voted 93% for Kamala. But it is a strategy that would undermine our constitutional structure. Judge Alito wrote this in a dissent. He said, unlike impeachment, the most important decisions in the process of criminal prosecution would lie in the hands of unaccountable grand and petite jurors, deliberating in secret, perhaps influenced by regional or other concerns that are not shared by the general polity, by the nation as a whole, guided by a prosecutor who's only indirectly accountable to the public, like Bragg or Bannon. So accordingly, Trump's defense says, well before the inauguration of President Trump even happens, it's coming soon, this Court of Appeals in Georgia should inquire into its jurisdiction. Can you even hear this appeal? You have no authority. That inquiry that you said you should do should result in this court deciding that both this court and the trial court lack jurisdiction to entertain any further criminal process against President Trump, as the continued indictment is unconstitutional. Trump respectfully submits that upon reaching this decision, this court should dismiss his appeal for lack of jurisdiction and directs the trial court, Judge McAfee, to immediately dismiss the indictment against President Trump. And of course, signed by Steve Sadow, who we saw just crush the last time we were here covering the disqualification hearing sometime.
Morning, someone. Evening.
December 4th. So
it's been a long day. I still have a long day to go. I got to go all the way out to Green Springs.
Feels like it's a likely possibility that something happens that disposes of this case, given the fact that we were scheduled for oral arguments, I think tomorrow, actually. I just deleted it from the calendar. We were supposed to have oral arguments on this, and now gone, because the Court of Appeals probably knows what they're going to do on this. So he submits it. Now, if they come back down and they dismiss it against President Trump, they will still proceed forward, I would imagine, theoretically, against the other co-defendants, because they didn't get elected president. They don't have any other immunity. So Fannie Willis can still dig her heels in and move forward against the other co-defendants. But the other co-defendants also have a problem with everything that has happened, as they should, because the case is being corrupted. You remember this guy. We talked about him and his plea deal. He took what I read as a diversion plea deal. Fannie Willis, as far as we can tell, and I know there's other lawyers who disagree with me, and there's other people who disagree with me, who say that what we read in their own filings was that Kenneth Chesebro's, Sidney Powell's, and Jenna Ellis's plea deals were diversion deals. So what happens is you get a guilty plea, but you don't have a sentencing that occurs. You put the case basically in abeyance. You come back after a short term of probation, and then they dismiss the case, and you do not have any guilty plea or any guilty conviction. That's how diversion works. Now, different states call it different things. They might call it deferred adjudication or deferred prosecution or whatever, but it's the same structure. You do something with the court, pay some fines, do some community service, whatever, and they literally dismiss the case. Now, that doesn't mean that you were never charged or that you never took a guilty plea, but the guilty plea is shredded up. It's not entered into a judgment against you and the case is dismissed. That was our reading of these many times ago, but when we covered all of them a long time ago. But that is not where he is letting this stand. Now, we'll read through his filing, we'll see what he says about his deal. But this is Kenneth Chesebro, and even though he was going to get that deal, he still wants to undo the plea deal. So he submitted a filing into the court saying that my charge is unconstitutional. Here's what he wrote. He says, all right, in the Superior Court of Fulton County, we're back in McAfee's courtroom. Kenneth Chesebro says, all right, listen, Your Honor. Kenneth Chesebro is now here with a plea in bar. Now, that's a legal challenge to the validity of an indictment. And it's not a common thing that you see. It says, when a plea in bar is when the defendant shows by matter extrinsic of the record that the indictment is not maintainable. And different states call these different things, but you can think of it as a post-conviction form of relief, right? The trial is over. He already took a plea deal. The trial never happened, but he took a plea deal, so his part of the proceedings, the pretrial process, is done. But you can think about a good example of this when we talk about post-conviction relief. Or if I was explaining this to a client, well, the theory would come up. Well, what happens if I learn after I take this deal that the cop was discovered to have planted evidence, right? Oh my gosh, like 6 months go by, you already have pled guilty to this, and so your part is done, but we learn 6 months later or a year later, this cop has now been indicted because he got busted planting evidence.
Yeah, I'm heading,
we look back, oh my gosh, it wasn't
Green Springs.
So he added that and added this, we had no idea, and he lied about this, and so we were forced it. So you say, well, that is obviously not justice, so there are mechanisms in the law by which you can reopen the case. So here's what he's saying, right? That is the idea of extrinsic evidence, not a part of the case record that you may discover after the fact. Now, generally speaking, this court retains jurisdiction over Chesebro because he's on probation, pursuant to the diversion rules. Now, Article 1, Section 17 of the Georgia Constitution provided that legislative acts that are in violation of fundamental law are void, and if it is unconstitutional, it cannot stand. So with that being said, he says, now we're challenging count 15. This request is predicated on the court's order which found count 15 previously invalid back in September. Now, on October 20th, the district attorney offered to dismiss 6 of the 7 counts in exchange for the guilty plea to count 15, which would be entered, here it is, under the First Offender Act. That's their diversion program. Mr. Chesebro agreed to this resolution, and his guilty plea was accepted and entered by the court. Now, in Georgia, and again, all of that, we read through the document, was basically held in abeyance because he's a first offender. So it's like your first strike, they don't make you a convicted criminal. They allow you to get out of it, which is what he entered. And he was like shocked. I remember watching the video. They're like, are you happy with the services of your lawyer? He's like, yeah, I am. He's like, holy crap, like this whole thing's going away? We're like, yeah, he is happy. Now in Georgia, a defendant cannot plead guilty to a charge that does not constitute a crime. Makes sense. By pleading guilty, Chesebro waived all defenses except that the indictment failed to charge him with a crime. Saying, in this regard, if a defendant can admit all the allegations contained in the indictment, yes, everything that you wrote in there is true, but you didn't articulate a crime. You can have an indictment filled with plain blow, filled with all sorts of garbage, but the indictment has failed to sufficiently say that Chesebro committed a crime. There's another case that says, if the defendant can admit every allegation in the indictment, so everything they claim is true, but there's no law that any of those things that they claim are true, is illegal. Now, although this motion is titled a plea in bar, another vehicle for relief is a motion in arrest of judgment. Another mechanism to file a post-conviction challenge to challenge the validity of the indictment. They say in Georgia, we also have this case. It's called Wood versus State, written back in 1871. We also filed another motion to dismiss count 15 under the Supremacy Clause back in September. Now, a plea in bar is a challenge to the validity of the indictment, and this mechanism can be utilized post-conviction. They say count 15 was a conspiracy count under Georgia law 16-4-8. The conspiracy was predicated on another portion of the law, which in relevant part purported to make it, quote, this is what Fannie charged in the indictment, make it unlawful for any person to knowingly file, enter, or record a document in a public record knowing that it contained false statements. Count 15 in Fannie's indictment said that Chesebro was one of 10 co-conspirators connected to the filing of the electoral votes to the federal court, right? So Chesebro sent a document into the federal court. Well, this is curious Because the federal court, isn't that a federal crime? Why does Fannie have jurisdiction over sending something into the U.S. District Court for the Northern District of Georgia? That's the federal court, not a state court. Fannie doesn't have jurisdiction to pursue crimes against them. On September 12th, this court, McAfee, held that count 15 being predicated on Georgia law is unconstitutional.
Yeah, I'm going to.
The reason being is that federal law preempts.
I'm hoping this doesn't take too long.
Perjury and false filings in the federal court,
And I'll be able to watch a portion of
thereby
it.
requiring
driving
count
home.
15 to be quashed. He says it is simply beyond the jurisdiction of Fannie. You can't charge somebody for filing certain documents in a federal court. That's their problem.
Hey, Brandon.
As a contrary holding would enable the state to constrict the scope of materials that are assessed by a federal court, and it would impinge upon the jurisdiction of that court. So it's their business, not yours. So beyond the requirement of Georgia law that Mr. Chesebro's plea be voided since Fannie charged him illegally, and count 15 be dismissed
my earbuds on.
a failure to
plug
grant the
them in.
relief would also violate Chesebro's due process, saying it's not okay to allow a person to serve a sentence for a crime that is not a crime. An unconstitutional law is void. An offense created by it is not a crime. A conviction under it is not erroneous. It's illegal. Here, Chesebro says the charge that McAfee says is unconstitutional, that he pled guilty to, is invalid, and it has to go away. Signed by Manubir Aurora, attorney out of Georgia, Aurora Law. Shout out on a good filing. Manubir sent in on behalf of Kenneth Chesebro. And that's going to be an interesting thing to see what Fannie says. And I don't know what the rules are in Georgia. What is the standard to overcome or to get out of a guilty plea? It's usually a very high standard. Because as we saw when we went through the Kenneth Chesebro filing, and that video is up on YouTube if you want to go back and watch that. When he was entering his plea, we learned it was all about the First Offender Act, and it read to us like a diversion deal, meaning that he would take this guilty plea, but it would ultimately go away and be dismissed against him under the First Offender Act. As long as he doesn't screw something up, if he violates probation or gets in trouble again, they can enter the judgment against him. But that's not going to happen.
Oh, yeah.
Now he's saying,
Krampus
I don't
Day.
even want to be on probation for the remaining 2 years or anything else, because Fannie is so incompetent. She charged a crime for a victim over which she has no jurisdiction, which is the federal courts. And then she made him plead guilty to that. And I don't know if his lawyers were onto that. They're saying, we're going to fight this later. This will go away.
December 5th, Krampus Day.
But generally, once you take a plea,
Yeah.
it's hard to get out of it. Judges
The Feast
say,
of St.
"Well,
Nicholas."
You knowingly took it. This is your deal. You agreed to it. But if the charge itself is invalid, the judge can't enter an unconstitutional guilty plea. So I like the filing, and I think there's a good basis for it, since the judge himself articulated count 15 was illegal. So Fannie Willis having a rough time. Kenneth Chesebro is going to be fighting to get out of that case. We'll see if Sidney Powell jumps back in. We'll see if Jenna Ellis jumps back in. But Fannie having a rough day out there in the noxious land of Fulton County. All right, and so let's turn our attention now over to Jack Smith and this new filing, because he's clearly really wanting this to happen. Jack Smith is so nervous that the January 6th case is not entirely dismissed that he moved to dismiss it again. We've already seen the first motion to dismiss, and we saw Judge Chutkin's order granting the dismissal back on November 25th, where everything in the January 6th case was dismissed, and we were very happy about it on that day, but also very irritated about it, because what we're seeing is Jack Smith is running and hiding, trying to wrap this up like no harm, no foul, don't be mad at me, and it's not so fast there, buddy boy. Congress is digging into this, saying that there was malicious prosecution, lies, and ethical misconduct that came out from Jack Smith that we're going to look at here in a second. But Jack has already gotten his dismissals, and he submitted a second motion to dismiss. Like, really wants it gone. And here's what he said. He said, Judge Chutkin, on November 25th, the court dismissed the operative superseding indictment without prejudice. We read through Chutkin's filing here. But remember, it was the superseding.
St. Nicholas?
There were two indictments. Jack Smith's first indictment was bad, so he had to do it again after the Supreme Court scolded him and said, dum-dum, you can't charge a new conduct in your original indictment. So he's like, oh. So rather than having to dismiss the case, he just filed a superseding indictment, stripped out that immune conduct.
Pennsylvania plate in front of me.
This is good enough. I took out all the bad
30,
stuff.
is that you?
Then submitted the superseding indictment. So think of that as indictment number 2. So the motion to dismiss was about the second indictment. The clerk acted on the court order, and the docket now reflects the absence of any
It's a big
pending
building here,
charges
First
against
Solar.
Trump, and it does classify this case as closed, right? But nonetheless, still a little nervous. Nonetheless, because certain out-of-case circuit case law indicates that a superseding indictment does not void the original indictment, like in this case in the First Circuit, the government now supplements its dismissal motion to avoid any doubt that for all of the reasons set forth in our first motion to dismiss, the original indictment is also dismissed without prejudice. Okay, so let's just ensure like it's gone. The government has conferred with Trump's defense, who does not object to the relief requested. All right, so signed by Jack Smith, special counsel, so-called. Yeah, right. Let's put an asterisk right there. He's not a real boy. He got booted out of Florida. So, illegal special counsel Jack Smith signed this one. He's like, please make sure it's dismissed, because we've been shredding like crazy here. So Judge Chutkin will, of course, grant that, and that will clearly be the close of that. Jack Smith filing twice to dismiss it. Now, he's not out of the woods yet. House Judiciary, the GOP, sent a letter over to the Office of Professional Responsibility saying Jack Smith is a real bad boy, saying Chairman Jim Jordan demands that the DOJ produce the requested documents, and there are some juicy requests inside. You see this one coming from Jim Jordan, chairman out of Ohio. Committee on the Judiciary from the House of Representatives. The letter goes to Mr. Jeffrey Ragsdale. Now, he's a person at the Office of Professional Responsibility, the ethics body, if you can believe it, of the Department of Justice there in Washington. Letter signed by Jim Jordan, our friend from Ohio. He writes the following. All right, Mr. Ragsdale, ethics person. The Committee on the Judiciary is conducting oversight of you people. To date, despite several requests that we've sent to you, you have refused to provide critical information about your operations that would meaningfully advance our work. The information, obviously, that's what they do. They investigate themselves, they find nothing wrong. Shocking. While we appreciate you confirming an open investigation into Jack Smith's prosecutors, Molly and Jay and Pierce, you're on notice. We are concerned that your refusal to take prompt investigative steps will allow these attorneys to evade internal accountability, and they're just going to leave the department and run away like they're doing. On May 6th, we wrote to you requesting documents related to investigations from your office that you were investigating Jack Smith and his team. There were allegations that they lied to a federal court, that they manipulated evidence seized by the FBI when they raided Trump's house, and that they improperly pressured a lawyer representing Walt Nada, who was also indicted by Smith. Remember, Jay Bratt was talking to Walt Nada's lawyer.
Keeps freezing, really?
Stanley Woodward, and said, gosh, you're real sure.
The stream itself is going to get shaky when I go through the town up ahead, so hopefully it'll survive it.
Your client was going to be on team.
If not, I'll fire it back up when I come home.
Maybe I'll have to put in a word. On August 2nd, we wrote to you concerning serious allegations of professional misconduct regarding another person on Jack Smith's team, J.P. Cooney. According to a July 2024 report
beef
issued
jerky,
by
nice.
the Department's Office of Inspector General, Cooney, at the DOJ on Jack Smith's team, intentionally sought to impose an unprecedented and excessive prison sentence upon a criminal defendant, and then spread false conspiracy theories when his supervisors overruled his recommendation.
Hey,
Now,
420.
we requested that your office produce documents related to the Cooney investigation or the circumstances surrounding his
Stream's about to get
horrific
shaky.
logs.
It'll
To date,
recover once I
OPR
get through
failed to
town here.
produce any documents responsive to our request, or Congress, you're not giving us anything. So consequently, on September 12th, Jim Jordan says, in light of your failure to comply with the committee's request that we sent on May 6th and August 2nd, we requested that you, Ragsdale, make yourself available to the committee for a transcribed interview so we can get to the bottom of this. On October 8th, we wrote you again to reiterate our outstanding requests. Now, in response, the department from you offered to make you available to brief the committee.
Yeah,
As an extraordinary
definitely seen that,
accommodation to you,
Eggsy.
we accepted this offer. Now, during your November 19th briefing to us, our committee in Congress, you confirmed that your office did open an investigation into Jack Smith in June 23, after an attorney from Jack's own office self-reported potential misconduct to you. Whoa! There's a good prosecutor on Jack's team? Man, I hope it wasn't Molly, because we've been pretty mean to her lately. But somebody said, yeah, we're corrupt scum. Good for them. You stated that per department policy, despite self-reporting a misconduct by Smith's own team, you said your office did not conduct an inquiry or an investigation into the allegations during the pendency of litigation in the cases brought by Jack's office because it could interfere with or jeopardize the prosecution. You see that? This is insane. So somebody on Jack's team says, hey, we're being corrupt and horrendous political hacks. Well, that's true, but you're in the middle of doing it. We'll investigate this once you're done being political, unethical, partisan hacks. Then we'll look into it. But we don't want to do anything to interfere your process of being corrupt. Look, that's the Office of Professional Responsibility that says keep being unprofessional, and we'll look into it later. As you explained it, the department's policy would keep bad actor attorneys in place to continue prosecutorial misconduct when they're breaking the law, which is acting as a co-conspirator to allow them to abuse their office to target innocent people who deserve the presumption of innocence and all the civil rights afforded to them. Because of the administrative difficulty and the resource constraints involved in switching attorneys. They don't want to replace Jack Smith. They can't. This excuse not only defies common sense, but it seems to violate the department's mission to ensure that justice is done in every case. This is huge, man. Who is this person? Jim Jordan knows. Who self-reported, Jim? After Smith told the media that he was, quote, expected to leave the department because he's running it.
That was -2 here with
Trump
wind
assumes office,
this morning.
his team was, quote, making moves to wind this down. He's running. Smith then gave your office permission to investigate the allegations of the attorney misconduct. So he said, but now you can investigate us. We're done. You stated that Smith only allowed the investigation to begin because it would now no longer interfere with his corrupt prosecution. They say this is absurd. That you, the department charged with upholding ethical conduct, would only examine allegations of prosecutorial misconduct after the subject of the allegations has approved the inquiry. I'll allow you to investigate me now. I've shredded all my files. Go ahead. This process does not inspire any confidence with your corrupt office that any of this is going to be independent or impartial. Now, during the briefing when you sat with us in Congress, you declined to give the committee a time frame in which your office would complete its investigation.
Yeah, we are here too.
Report and findings. In addition, you wrongly stated that the committee could not receive a copy.
Then back
of
down into the
final report
30s
because
next
of the
week.
Privacy Act. Well, as we explained during the briefing, the Privacy Act has an express exemption for disclosing material to the committee chairman such that it is not a barrier to you cooperating with us. Your continued failure to cooperate with our oversight and apparent intention to hide information from us is more evidence that your office operates to protect the DOJ from any independent accountability. OPR needs to go too. Everybody there, Pam Bondi, hopefully cleans house. Pursuant to the rules of the House of Representatives, the committee is authorized to do this and investigate you. As stated, Congress has long considered legislative reforms for you, including proposals that would remove your exclusive authority to review allegations of ethical misconduct against DOJ lawyers. The department and your failures to give us any information demonstrate we need to know why you should exist in the first place. Now, the committee accepted your briefing as an accommodation to the department in an effort to advance our oversight. Unfortunately, though, there were several areas of
he was in my chat
about
earlier,
which you were unable to provide any information, and so consequently, the committee reiterates our requests. We sent the letters again. This letter serves as a formal request as well. Preserve all existing and future records and materials related to your investigation of Jack Smith and members of his team. Your office should construe this preservation notice as an instruction to take all reasonable steps. Don't shred a thing. Don't delete your phones.
Oh, Lake Ontario,
like with a cloth or hammer like Hillary. Nothing. Text messages with the Chinese
New York
have now. Don't delete anything. As we have explained, the briefing did not alleviate any concerns about your inquiry into Jack Smith, and so get us these documents by December 18th or else. Your friend, Chairman of the Judiciary. So we'll see what OPR does. My guess is they're not going to turn over anything. They're going to turn over the bare minimum. It'll be redacted. They'll just wait until Trump comes in office, and they'll see if they can kick this can down the road to avoid any further and future disclosures. But I hope, man, of all things, that these people in Congress stay on this, because this is a bombshell, actually. Somebody from Jack Smith's team reported their own misconduct. That's shocking. And they continued their prosecution, and we never knew about it at all. The OPR allowed the corrupt prosecution to continue until Jack Smith authorized the investigation to begin. Surely, after all of the misconduct has been cleaned up, now Jack Smith is running away from this because he lost, and Congress, and I hope the new FBI, Kash Patel, Pam Bondi, and the rest of them stay on this and get to the bottom of what happened, because these people engaged in a collusion, conspiracy to deny Trump the presidency, and they abused their office to do that. That's a crime. We'll be here continuing to cover it, my friends. Thanks for subscribing and joining as we do. All right, now, let's turn our attention to Kash Patel and January 13th in Butler and our Secret Service, because things are getting spicy here as well. New FBI director appointed by President Trump named Kash Patel said he was not going to play around with the media. If they hit him and defame him and attack his credibility and legitimacy, they'll respond in kind. Well, this woman did just that, and she got a letter from Kash and his attorneys. She wrote this. She's an MSNBC contributor. She posted this, says, I just got a nasty gram from Kash Patel. We'll see what the letter says, and we'll also take a look at what's happening to Kash Patel, who has now been apparently attacked by Iran in a cyber attack. And there's more. A lot of reaction to Kash Patel and others in the government, including this Secret Service acting director, Ronald Rowe, got into it in Congress today. These two absolutely screaming at each other, and it was a sight to see. So we've got all that coming up and reaction. But we're starting with Kash Patel's nastygram to Olivia. She said, today, Kash Patel sent a letter to my lawyer threatening legal actions and demanding that I retract my comments on MSNBC about his unfitness to serve as the FBI director. This aligns with his threats against the media and political opponents, revealing how Kash might conduct himself if he's confirmed. I stand by my statements. I'm not retracting anything. My priority remains the safety and the security of the American people. I am not the only one who has expressed concerns about him, so why me? And so it begins. So here's Kash's letter over to her. He wrote the following from his attorney, the Biddle Law Group, December 4th, over to Olivia and Mark, her attorney, calling this a retraction demand and a document hold and preservation demand. Not played. All right, guess what? Dear Miss Troy, this law firm represents Kashyap Patel. Litigation will be filed against you if you fail to publicly retract defamatory statements that you made about Mr. Patel on MSNBC on December 2nd. Be further advised that you should identify and preserve all hard copy and electronic documents, information, and data that relate in any way to Mr. Patel and your statements about him on MSNBC. On December 2nd, you, Olivia, appeared as a live guest on MSNBC and made several false and defamatory statements about Mr. Patel. Now, these comments include that Mr. Patel would, quote, lie about intelligence. And you say he would, quote, lie about making things up on operations to the point where Mr. Patel put the lives of Navy SEALs at risk when it came to Nigeria. And you said that Kash Patel was even misinforming Mike Pence. Now, Olivia, this is a complete fabrication, and you know it is false by virtue of your former position in the White House. At no point did Mr. Patel ever lie about national intelligence, place Navy SEALs at risk, or misinform the vice president. Not only did you have actual knowledge of the falsity of the smear, so you know it, but you also did so with the malicious intent of degrading his character and of cynical self-promotion. I'm not an MSNBC. This is, of course, not the first time that you've milked your former title as a means of spreading lies about your associates, President Donald Trump. You've already embroiled yourself in a lawsuit for your disgusting lies about Ambassador Rick Grinnell. So Mr. Patel demands that you retract your lies in a public statement on your X account within 5 business days of receipt of this letter. She did not do that. She said she stands by her statements. She's doubling down. I stand by my statements, Kash, so you can just shove it. I stand by them, she says. They say, unless this step is taken, Mr. Patel will take swift legal action to uphold his rights and his reputation. Now, with this letter, you were also on notice of your ongoing obligations to preserve documents related to Mr. Patel. And accordingly, you must ensure that you, your agents, and all sources of information upon you which relied are preserving all of your documents. Facebook, Signal, WhatsApp, Telegram, and more. Audio-visual recordings and anything that relates in any way to any of these conversations. Without any limitation, this requires you to preserve all your research and due diligence you conducted, if you did any, and instructed others to conduct relating to Mr. Patel. Olivia. The laws and rules prohibiting destruction of evidence apply to electronically stored information as well. Don't you be deleting your things. This includes backups. Don't delete those either. Now, please confirm receipt of this letter and confirm your intent to retract your statement within 5 business days. And please also confirm you intend to adhere to your obligations to preserve all of these records. Now, this is not a complete recitation of Mr. Patel's rights and remedies, all of which are expressly reserved. Sincerely, your friend, Jesse R. Bunnell, coming at you from Bunnell.com. And Kash Patel, not playing around. So we'll see if this ultimately goes to litigation. A lot of the times, these things don't actually mature into litigation. We'll see if they do, though, based on her statements, which clearly, according to Bunnell, seem to hit the standard for defamation. Actual knowledge about the falsity plus a malicious intent to harm the character of another person, doing it with a self-seeking motive to go get money and show up on MSNBC, goes for the Secret Service. Now, this was an interesting exchange today that was fiery. Representative Pat Fallon was there. There was a hearing today on the Butler January 13th assassination attempt of President Trump. And one of the most useless people in our federal government called Ronald Rowe, he came out and started screaming at this representative for asking him questions and holding him accountable. And we talk about this all the time. If you have the law on your side, you pound the law, right? You play to your strengths. If the law is not looking good for you, like the law doesn't work for you, but you have good facts, well, just talk about those good facts all the time.
Oh, Pete Hegson too,
And
the
if you
big
have
time.
neither of those, well, then you just pound the table. So pound the facts, pound the law. You don't have them.
Those are the ones you really want to get in, though.
It's an analogy that might apply, or a methodology that might apply to many things in your life. Just change the law, the facts, and the table. It applies to you. But that's exactly what Roe was doing here, screaming because he had nothing else to say. This is very interesting exchange here. You can tell this person might have some anger management problems. Maybe probably shouldn't be leading a group of other people if he can't even sit in Congress and answer simple questions without spiraling off like a friggin' lunatic. But here's how it went down today. It's a spicy one.
Recognize his phone. Yes, sir, I do. Okay. Is that the remembrance of September 11th? It was. Is it in New York? It was at Ground Zero. Okay. Who's usually at an event like this closest to the President of the United States? Security-wise. Sack of the detail. Special agent in charge of the detail. Were you the special agent in charge of the detail that day? Actually, let me address this. Could you please, staff, leave that? Oh no, leave that one up with the circle around it. Thank you. Actually, Congressman, what you're not seeing is the sack of the detail off out of the picture's view. And that is the day where we remember more than 3,000 people that have died on 9/11. I actually responded to Ground Zero. I was there going through the ashes of the World Trade Center. I was there at Fresh Kills. I'm not asking you that. I'm asking you, Congressman. Were you the special agent in charge? To show respect for a Secret Service member that died on 9/11. You're trying to be. Do not invoke 9/11 for political purposes. Oh, I'm not. I'm invoking this. You are, sir. And you are out of line. I would like to ask him a question, please. You are out of line. Bully me. Don't try to bully me. I am an elected member of Congress, and I'm asking you a serious question. And you are I am a public servant who has served this nation and
Pound the table.
time on our day, on our country's darkest day.
The meeting will come to order. The meeting will come to order.
I'm asking you serious questions for the American people, and they're very simple. They're not trick questions. Were you the special agent in charge that
No,
day?
I wasn't. I was there representing the United States Secret Service, sir.
Mr. Ballin, your time's
It did not
expired.
affect protective
Well,
operations.
you were there because you wanted to be visible because you were auditioning for this
I was
job.
there to
and
pay
you're not
respect
gonna
for a
get it.
foreign
You
member of this
endangered
agency.
You endangered
You are
President
out of line, Congressman.
Vice President
You are out of
Harris's
line.
life because you put those agents out of position. Did you have a radio with you?
Mr. Ballin, your time has expired.
I did, sir, and you are out of line.
Mr. Chairman, Mr. Chairman,
Yes, sir.
please.
You're back in order now.
Thank you.
I don't want to run for Congress after watching that, right? I think they maybe should just go down there, arm wrestle, thumb wrestle, or something, and just settle this. But it was very explosive, obviously, as you can see. And what we saw there is a person who is pounding the table. It's a great example of this. Just screaming and pretending like he's fighting for the Secret Service agency and like all the Secret Service agents are going to love him for defending them. We know what you're doing, man. You allowed him to get shot in the head. So scream all you want about 9/11, which was another intelligence failure from you idiots who are in charge of protecting the country. You guys were terrible at your job. So thanks for that. Yeah, and we do pray for all the men and women who killed that day. What was the FBI, the CIA, all of these agencies doing? That 2 planes flew into our buildings. All right. And then Trump gets shot in the head. And he's going to sit there and say that you're a bad person for asking him questions about all of his failures. And by the way, Roe has been in the Secret Service since 1999. We looked it up this morning on the members only stream. And they were playing to him like he got handed this big mess on his lap. He's been in there. He's been part of this degradation over the last several decades. So people like him should be the first to go. If you're part of the sinking ship, you're not part of the solution. You've been there for 30 years. Time to go. So he just pounds the table because he's got nothing else to say. But Susan Crabb...
No, he was just like Rob was saying, though. He's pounding the table because he knows he's wrong.
Because she gets all the
Basically
secret news from
filibustered that
She hears all the
congressman's
things. She
time.
wrote Scoop. Secret Service
screaming.
sources are incensed over this case.
I fault the congressman too for engaging in that.
They're like, they can't even believe it.
Because if you just let him scream, he's the idiot. But when you scream back,
Roe is saying that he had a right to move the top agents assigned to protect.
well, he deserved to lose his time because he was responding to it.
Because he worked either on or after 9/11, helping sift through the debris. Makes no sense. Makes no sense. He joined in 1999. What was he there doing? Cleanup. Was the Secret Service there part of the 9/11 cleanup efforts? What? Makes no sense at all. Now, while that work is honorable, and the nation owes him a debt of gratitude for that, because it likely involved trying to find survivors, I'm told hundreds of Secret Service agents were called in to do that work. They were, I guess, in the weeks after 9/11. That work involved going to what is called the Fresh Kills landfill. It was not at the World Trade Center itself. So what did he actually go there? I have several questions into the Secret Service press office to clarify exactly what he was referring to. Thank you, Susan. What the hell's he talking about? Also, being assigned to work on or after 9/11 has nothing to do with why he chose to be in the 9/11 in the photo op and change protective protocol by moving the top agents farther away from Biden so that he could be seen, right? He moved them away so he could have his face there. Fallon asked if he was jeopardizing Biden and Harris's lives by doing that, whether he had a gun or a radio on him. Then he started screaming, 9/11! Rose said he had a gun and a radio and claimed that the protective mission wasn't compromised. Sources say it's hard to tell if he had a gun on him during 9/11, but he's not wearing an earpiece, and that means he was not in the protective posture and likely did not have a radio on him, right? So, screaming lunatic who is doing a terrible job at the Secret Service and has been doing a terrible job there for decades.
Yeah, I did.
Is moving people around so he can be in photos with Biden. All right. So that's
Open-faced roast
Now, we
beef
got
sandwich
questions
with
about Cash
gravy and
Patel,
mashed
there's
potatoes.
a debate that's happening right on Capitol Hill over this. Some people say Cash Patel is going to be terrible, and some people say he's going to be amazing. So here's one who is a Democrat senator called Chris Murphy from Connecticut against Cash Patel, and we'll see what Mark Wayne Mullen says in favor of Cash Patel, starting with this fellow.
This announcement that Donald Trump is going to fire the director of the FBI.
Bye, Chris.
His term is not up. And put in.
Doesn't matter. Doesn't matter that his term is not up. It's not a you get all 10 years. Here's an exception to that rule. If you're an FBI director who authorizes a raid of the incoming president, you don't get to get grandfathered in, okay? Because you raided his wife's bedroom, okay? Murphy. So there's no precedent for that to keep him on, right? Because he did that. So now it's time for him to go.
Cash Patel, a political sycophant.
Yeah, okay. Like Merrick Garland is not of the Democratic Party.
And I don't completely understand why everybody doesn't understand how big this is. Donald Trump told us
We do.
during the
It is big.
campaign that if he was going to be elected, he was going to use his power.
That's
to
why we
turn
elected him.
the Department of Justice
Yes.
and the FBI
Yes.
into a political witch hunt
No, that's not what he said.
to go after
That's your framing of it, but he is going to go after the people who broke the law there, Chris.
his political opponents.
What? You guys broke the law to target him, to remove him off the ballot, to prosecute him in 4 different jurisdictions organized by the White House itself. You were probably a part of that, which is why you're freaked out about this.
And he's doing it.
Good.
That's what
He won.
Cash Patel's qualification is to be FBI.
Oh, MCC's got a premiere from Rock Island coming up.
The FBI should be
It may be playing now.
of hunting down
Criminals.
political opposition to Donald Trump.
Broke the law.
What does that mean for you? Well,
Now we're going to have less criminals in the FBI and the DOJ who are trying to prosecute politicians.
first, it means that there's no political dissent or speech in this country that is safe. But second, it means that the FBI is
You're speaking right now, weirdo.
going to get out of the business of actually going after.
Yeah, he's window shopping.
criminals.
Like who? January 6th?
Yeah, I'm the stream's over with.
Safe.
I'm 2 minutes away.
Gun smugglers,
Go check it out.
drug traffickers, corrupt Wall Street executives.
Like who?
Instead,
I'll go ahead and end it.
spend all their time
Y'all have a good night. I may see you guys on the way home. We'll see how I feel.
or people who think
If not, I'll definitely see you guys tomorrow. Peace.
This is an assault on democracy, but it's also an assault on